Do sit down, everyone, except Mr. Biggs.
Thank you, my lord, and good morning, my lady and my lords. And may it please you, as you know, I appear on behalf of the Appellant Secretary of State for the Home Department. My only friend, Mr. Adam Pipe, appears on behalf of the respondent, who has been anonymised by order of Lady Justice Lang as AB. My lady, my lords, there are some housekeeping issues that I need to deal with. There are issues with the bundles, for which I apologise. We have just made available amended version of the hard copy of the authorities bundle, which contains the most authoritative reports in the HA and others and the KO and others decisions at the Supreme Court level, because we thought you would need those.
Yes, thank you. That saves me being grumpy, as I would have been, to say that the practice direction about citation of authorities in the law report form is still in force. But thank you, that's been noticed.
I'm grateful.
It's a pity to have reproduced 400 pages worth again.
I appreciate that. It's an unsatisfactory stage of affairs. We had to make a judgment about how to remedy it, and
yes,
that's what we did. There's also a short supplementary authorities bundle that contains my Lord Justice Bean's decision in the Capicaya case, which we think you should also be aware of. Yes. That's at the end of the bundle.
Oh, I see. Yes, the index.
So we've marked that with a pink or lavender tab, I think. So you should be able to find that at the end. Again, I'm sorry that it's...
Sorry, which one is added at the end, did you say?
It's a supplementary authorities bundle that goes in primarily because of the Capicaya case.
Yes.
But it also contains the relevant immigration rules and a complete array of relevant statutory provisions.
Oh, I see. Yes.
Just in case the court was interested to look at that material.
Yes. All right. Yes, we've got those.
I'm very grateful. The final matter of housekeeping in terms of bundles concerns the core bundle. That omitted the order granting permission. I think that's been remedied by my lord,
yes,
my lord and my lady's clerk. But we've got hard copies here, and we filed an updated electronic version of the core, yes, bundle yesterday that contains the order. For those of you who at some point might look at the electronic bundle.
Yes.
So, my lords, my lady, unless there are any preliminary issues that I need to deal with, and I don't think there are, subject to any observations from the bench, what I propose to do is to jump right into my submissions. I had intended to say a little bit about the legal framework and relevant principles before turning to the Upper Tribunal's decision, and then the grounds of appeal, and finally setting out our position on remedy or relief, if you're with us on any of the grounds of appeal. I'm not sure, though, how helpful it will be to take you through at any length at all the legal framework and relevant principles. They are well known to this court, and they have been set out in various authorities, and they are accurately set out by the Upper Tribunal below in this case. So I'll be led by the court, but I had intended to at least truncate that section of my submissions, unless the court would be assisted by a more thoroughgoing consideration of the relevant principles and statutory framework.
I don't think you need do that by way of introduction. When you come to the contentious bit about where you say the Upper Tribunal went wrong,
yes, you
will no doubt refer to one or two authorities, but I don't think you need to do it by way of general prologue.
I'm very grateful. That's what I thought as well, so I'm grateful for that indication. I'll proceed in that way. So the first port of call then, in terms of my submissions, is the Upper Tribunal's decision. That is at page 26 and following of the core. And again, I'll be led by the bench, I suspect, my lady, my lords, have carefully considered this decision in advance of the hearing, but in any event, I will go through it to identify the key sections of the reasoning, and then I'll focus in on what I say is the key reasoning. This was a decision following reconsideration of AB's appeal from a decision to deport him that refused a human rights claim. The first tier tribunal had allowed AB's appeal, but had not looked, certainly not in any detail, at Article 8. The appeal was allowed effectively on asylum grounds. The Upper Tribunal set aside the first tier tribunal's decision by a decision promulgated on the 4th of December 2023. That's at page 39 and following of the core. We don't need to turn that up. And the matter came for rehearing before a different panel of the Upper Tribunal to that which considered the matter at the error of law stage, who made the decision that we challenge in this case on the 26th of June 2024. At paragraph 7, page 27 of the core, the panel of the Upper Tribunal identified findings that had been preserved, findings at the first tier tribunal level that had been preserved, at the error of law stage. It identified the issues at paragraph 8. And it's issue C that is now the focus of the appeal. At paragraph 9, the Upper Tribunal set out the relevant aspects of sentencing remarks given by His Honour Judge Berlin on the 13th of October 2020 in respect of the most serious offending perpetrated by this respondent, and we would invite you to carefully note what's said in the quoted passage, which I won't emphasise in my oral submissions. You have it in writing, and we urge you to take careful account of it. At paragraph 10 and following, the Upper Tribunal set out the evidence that was before it. And again, I won't identify any particular aspects of this section of the decision, but you will need to carefully bear it in mind. It might, though, be worth just looking briefly at paragraph 13 in this section of the decision on page 30, where you have AB's partner's evidence summarised in respect of why she says she would not be able to go and live in India with the respondent. It's in particular, I think, the last 5 lines of that paragraph. So there are 2 points that she raised in her evidence. She'd lived in the UK all her life and was born in the UK, but she also said that she would be at risk from a maternal uncle who is a politician in Pakistan and had connections to India. She said she believed that it's likely that that person in some way would put her and her daughter, the respondent's child, at risk in India. Paragraph 14 is also relevant on that issue. Evidence from the appellant's sister-in-law, so partner's sister. She also referred to a maternal uncle and gave a little bit more information about him. to the last sentence of paragraph 14. The tribunal then set out the legal framework, which we don't take any issue with, at paragraphs 15 and following. At paragraphs 21 to 25, the tribunal upheld.
Well, just pausing there.
Yes.
You'll come to the law later. You say you don't take issue with the legal framework as set out. Statutes, paragraphs 15 to 18, and extensive citations from HA Iraq at 19, Yeltsin at 20.
Yes.
You don't take issue with that, but I think you're saying you don't take issue with it as far as it goes, but it should have gone further. And as Lady Justice Elizabeth Lang pointed out, there's no reference, for example, to Lao.
Indeed. Indeed. So there's nothing, if you just take this section of the Upper Tribunal's decision out of context and just look at it as a sort of textbook entry, there's nothing wrong with it. But we say the Upper Tribunal did go wrong in a number of respects by applying these principles, and in particular by overlooking Lao and the implications of Lao. So we then get to paragraphs 21 and following, where the Upper Tribunal explains that it upheld a Section 72 certificate. It noted at paragraph 22 and 23 that there was an indication that the respondent here, AB, presents a high risk in the community. And ultimately it concluded, see paragraph 25, that the presumptions arising under Section 72 had not been rebutted, and that was an answer to the asylum claim. At paragraph 26 and following, the tribunal considers Article 8, and this is the crucial aspect of the Upper Tribunal's decision for our purposes, in my respectful submission. Paragraph 26 notes AB's immigration history. It's acknowledged that AB's partner and AB's child are a qualifying partner and qualifying child for the purposes of Part 5A of the Nationality, Immigration and Asylum Act 2002, having regard to Section 117D. So just to trail the point, that if you like, gets AB possibly into Exception 2 in Section 117C, which is provided by Section 117C sub 5. It's accepted that there is relevant family life between AB and AB's partner and AB's child, paragraph 27, and that there's an interference with that family life for the purposes of Article 8. So Article 8 is, if you like, engaged. It's then acknowledged, paragraph 28, that AB is a foreign criminal as defined in Section 117D2, and also, for the sake of completeness, I would add Sections 32 and 33 of the UK Borders Act 2007. The court then notes, the tribunal, notes that paragraph 29 that sets up a high threshold for AB to meet because of, it's implicit here, but it's because of the very strong public interest that arises in a case like that in support of the deportation of AB. At paragraphs 30 to 31, the tribunal considers Exception 1 in Section 117C sub 4. An aspect of that is whether there are very significant obstacles to the appellant's integration into India, and it's that aspect of section 117C4 that the tribunal focuses on in those passages. It concludes that the exception is not met on the evidence, and indeed that there would not be very significant obstacles to reintegration or integration. See the end, paragraph 31. At paragraph 32 to 36, the Upper Tribunal considers section 117C sub 5. That's the unduly harsh exception, if I can put it in that shorthand way. And it concludes at paragraph 36 that it would be unduly harsh for AB's partner and AB's child if AB were deported to India. Reliance is placed on an independent social workers report at paragraph 34. In respect of AB's child's best interests. It's said, it's noted that that report states that it's probable that AB's child will feel an acute sense of abandonment should her father's absence become long-term. And it's also noted that in that report, AB is said to present as a considerate partner to his wife who has significant and enduring mental health problems. And just on the mental health problems, there is nowhere in this decision any clear explanation of what those mental health problems are. It might be worth just quickly looking at the independent social worker report that's being considered at paragraph 34 of the UT's decision here, to try to shed some more light on what the Upper Tribunal had in mind. I'm sorry to jump around a bit, but I think that might be helpful. So that document is at page 156 of the core.
Yes.
And at paragraph 2.12 on 163, the author of the report records what AB's partner told them in terms of their mental health situation. It's the sentence beginning, she describes,
Sorry,
4 lines
where?
down.
Oh, I see.
So that's paragraph 212, page 163, 4 lines down, she describes, etc. And then at paragraph 3.4 in the conclusion section of the report, page 167, the author of the report refers to AB's partner's mental health possibly deteriorating in the event of AB's deportation, and in that event it said it is possible that AB's child needs will be at best significantly compromised or at worst unmet, but I emphasise the word possible in that passage. So going back to the Upper Tribunal's...
So there's reference to medication in 212, but there was no, so far as you know, there was no medical evidence presented to the tribunals, first tier or upper?
Certainly the Upper Tribunal doesn't refer to any. I've asked my learned friend who appeared in the first tier tribunal what any such evidence might have been, and he indicates that there may have been some sort of report, but I can't assist beyond that. But the important point in my submission is that certainly there is nothing in the first tier tribunal's decision in terms of findings, or the upper tribunal's remaking decision in terms of findings, that explains what the mental health conditions are.
Some sort of report from...
I'm not entirely clear.
Okay.
This is a discussion
Okay.
I have with my learned friend on this point because I appreciate its salience, but I'm not able to point you to evidence that explains what what AB's partner's mental health situation was that was before any of the tribunals below.
Well, we assume that if there was some report other than this one, which would help us, that was available, if you didn't put it in the bundle, Mr. Pipe's side would.
That's what we have assumed, that's right.
Yeah.
And I'd also add, with great respect to the tribunals below, one would assume that evidence would have been specifically mentioned and engaged with.
Yeah.
Just to complete this, it completely answers to my Lord's question here. Paragraph 1.2 on page 157, this is paragraph 1.2 of the Independent Social Workers Report, identifies the evidence that, or material I should perhaps say, that the author of the report looked at.
Yes.
So that does include, if you look at the next page, a prescription, but there's no expert report or records in terms of mental health issues. So going back to the Upper Tribunal's decision on page 36, I think we've finished paragraph 34, where the tribunal summarises the Independent Social Workers Report that we've just looked at. At 35, the tribunal specifically considers the best interests of AB's child and accepts that generally it's in the best interests of children to have a good relationship with each of their parents, but it's noted that that could be outweighed by other considerations. We then see an important passage in paragraph 36. The tribunal states that that AB's partner's evidence was compelling. Her evidence about family dynamics, in particular the breakdown of her relationship with her own family, was accepted. Very significantly for the purposes of the arguments made in this case, the next sentence, we have taken into account the evidence before us regarding the health of AB's partner, and then this, her subjective fear that she will be at risk in India, so that the family could not continue to live together in India. So it seems as though the Upper Tribunal had formed the view that the subjective fear was at least a significant and important consideration on the question of whether AB's partner could continue to live with AB in India. And then we see what might be called a concluding sentence, beginning looking at the evidence before us holistically. That sentence refers to family dynamics, and that's the extent of the reasoning in terms of exception 2, the unduly harsh exception, if I can call it that, under section 117(c)(5). The tribunal then correctly notes that that's not enough in a case like this, because we're dealing here with a respondent who was sentenced to 62 months imprisonment, so he is a serious offender under the scheme under section 117(c). And so the tribunal considers at paragraphs 38 and 39 whether there is, to use, I think it's Lord Justice Underhill's terminology from the Yeltsin case, the something more over and above the two exceptions in section 117C that lead to the conclusion that there are very compelling circumstances that make deportation disproportionate. The tribunal relies specifically on the impact upon the ability of the family to live together in India in the light of the subjective fear held by appellant's partner as to the risk that she and AB's daughter would be exposed to. This is the sentence beginning. There is an added dimension that starts, I think, 5 lines down. I think 6 lines down, perhaps. So 5 lines down into paragraph 38. In the earlier part of paragraph 38, it's also stated that AB had a difficult childhood following the death of his mother in 2004, and that he's been living in the UK for a period in excess of 16 years. It's also noted that AB's partner and AB's child are British citizens who have no connection to India. Towards the bottom of paragraph 38, the tribunal notes AB's partner's evidence, which it accepts, that she fled her family home fearing that she would be a victim of honour killing, and it's said that she remains resolute in her commitment to the relationship with the respondent here, with AB. It's then said that we accept the evidence of AB's partner that she'll be unable to join AB in India, and the implication of that is set out in the following sentence. If AB is deported, it is likely to lead to the breakup of the relationship, and in consequence the breakdown of the relationship between AB and AB's child. And then there's again a restatement of the fact that AB's partner and AB's child have no connections to India. And then there's a fairly generally expressed concluding paragraph in the next passage. Standing back, looking at the evidence holistically, it's concluded that there is the something more required in a section 117C6 case, but no further detail is given. Finally, paragraphs 40 to 41 explain that the tribunal decided that there would not be a breach of Article 3 or a real risk of a breach of Article 3 in the event of AB's deportation. So, my lady, my lords, unless you have any questions about the Upper Tribunal's reasoning, I'll turn now to deal with the grounds of appeal. What I propose to do is to deal with grounds 1 and 3 together. So that ground 1 makes the point about the challenges the Upper Tribunal's approach to what we call subjective fear, AB's partner's subjective fear. And ground 3 challenges the Upper Tribunal's finding that AB's partner would be unable to go and live in India with AB in the event AB is deported. The two grounds overlap to some degree, although ground 3 does make a standalone point, as I'll come to explain. So our short primary submission is that subjective fear is not relevant to the objective normative assessments that the Upper Tribunal was required to undertake in this case. It's not relevant to section 117B5, and it's not relevant to the 117C6 very compelling circumstances evaluation. And the reason for that is that it is trite law that those provisions require an objective normative assessment to be undertaken by the court or tribunal. And in this case, the subjective fear that the upper tribunal relied upon is really a placeholder for an unjustified, that is mistaken, belief that there is a risk from maternal uncle in the event AB's partner went to India. But an unjustified, that is mistaken, belief about risk should be irrelevant because given that the tribunal and court, looking at section 117C and article 8 more broadly, has to form its own view about whether objectively there is a risk. The alternative submission is that if subjective fear is relevant, it should generally, and I would respectfully submit in the vast majority of cases, is likely to be given little weight because of the potential for that factor to effectively convert what is an objective assessment undertaken by the tribunal or court of fair balance, proportionality and the statutory requirements in section 117C into an assessment that is undertaken subjectively, at least to some degree, from the perspective of the person affected by proposed deportation. And that would be wrong in principle. We also make the point here that a court or tribunal should be cautious in giving weight to a subjective fear, because a subjective fear, that is an unjustified fear, an objectively unjustified fear, is likely to be unstable and may well not persist over time as a result.
Sorry, I'm not sure I understand your submission that simply because it's subjective, it means it's unjustified. That looks as a conclusion, a conclusionary statement.
Yes.
And it might or it might not.
Yes, well, I'm grateful, my lord. So, in this case, what the expression subjective fear, which both the upper tribunal and the parties use, is in my submission actually a placeholder for what is an irrational judgment, an unjustified judgment or assessment of risk by AB's partner. Now, what do I mean by that? The tribunal in this case was clear, perhaps implicitly, but was clear that there is no proper basis, objectively speaking, for the view that maternal uncle presented risk to AB's partner or AB's child in the event that they went to live with AB in India. Now, in that situation, where AB's partner believes that there is such a risk, that belief must be mistaken. It may be understandable for psychological reasons, for example, but it is incorrect. And that is what I mean by unjustified.
That's on the basis that the tribunal decided that, objectively assessed, there was no risk.
Yes.
Where do we find that in the tribunal's decision?
Well, there's no, well, in terms of any risk to AB, there are clear findings that there wouldn't be any risk to AB. That's why the upper tribunal rejected the suggestion that section 117C4 lim C, that asked whether there would be very significant obstacles to integration in India was not made out. See paragraph 31, the last sentence of that passage. And it's also why, in the light of that analysis or conclusion, the Upper Tribunal concluded that there was no real risk of serious harm for the purposes of Article 3, see paragraphs 40 and 41. So there are clear findings in respect of AB and risk. I think I have to accept that there's nothing of similar clarity in terms of express reasoning regarding AB's partner and the risk that she had identified being objective or not justified.
I think there's positively no finding in the paragraph 32. They say whether or not RJ's maternal uncle has any reach in India. It is clear that she has a subjective.
I'm grateful. My submission is that reading this determination fairly and in full, the Upper Tribunal has either found that AB's fears, if you like, in terms of risk, are not justified objectively, or the tribunal has formed the view that it's not necessary to go on and consider whether they're objectively justified or justified, in the light of the conclusion that those fears are subjectively, that those fears are believed, even if only subjective. But in my submission, that second interpretation would be, with great respect, surprising, because an expert tribunal would appreciate the salience of whether there was indeed an objective risk, whether there was a justified risk or not. So one would expect the Upper Tribunal to have made clear that there was an objective risk, there was a justified risk. In respect of AB's partner's claims, if it was of the view that there was. I don't think, with great respect, it matters really, because the tribunal clearly relied only on subjective fear. And in my submission, subjective fear alone has to be contrasted with objective fear or objective risk.
But isn't it the case that because they've treated it as subjective fear is enough, which
yes.
you say is an error of law, they have not made a decision either way because it's unnecessary? That's what paragraph 32 seems to imply.
That's certainly one possible interpretation, my lady, as I've said. The other interpretation is that, albeit implicitly, the tribunal has concluded that actually this is only a subjective fear, it's not justified. My sense is that that is actually what the Upper Tribunal was saying, but I have not acknowledged that it's not set out in terms. That would certainly be consistent with the explicit findings in respect of risk to AB, and as I've said, it would be surprising if the Upper Tribunal did not make that finding, even if only implicitly, because this expert tribunal would know that it was a particularly significant matter to consider. So those are our submissions in outline. Now, just in a bit more detail, it may be helpful just to remind the court of what the law requires in this regard in terms of section 117b5 and in terms of section 117c6. In terms of section 117b5, that's the exception to unjustifiably harsh exception. The law was authoritatively stated in the KO decision at the Supreme Court level. And the relevant paragraphs are paragraphs, I think, 21 to 23. I hope at page 291 of the hard copy of authorities we handed up earlier.
Just a moment.
291 is not. Are you taking us straight to paragraph 21?
I am, my lord, yes. We can look at the beginning of the judgment if you wish.
Yeah, no, it's right, because 21 is on page. Have I got the right case? No, I haven't. Yes, I have. 21 seems to be on page 294.
Ah, I see. I'm giving you the references to the unamended authorities bundle, if you just bear with me.
It's also unhelpful. I've seen this case before. Each page is headed MA Pakistan.
Right.
The case is usually known as KO Nigeria.
Indeed.
It's the same case. Anyway, Carnworth, paragraph 21.
Yes. 21 to 23. Yes, so I think that's on 294, in fact, of the amended authorities binding.
Yes.
And in these passages, which the court will be broadly familiar with, I don't think we need to spend too much time looking through them in detail, but
No.
the essential point is that section 117C5 is self-contained in the sense that it does not allow for a wider balancing of factors. It asks whether the consequences for the relevant partner or child would be unduly harsh. Now, in my submission, the word unduly is clearly importing a normative assessment, which is a matter for the court or tribunal considering section 117C5 to determine for itself in the light of its findings of objective fact. So that's what section 117B5 requires. I should also, for completeness, just point out that the test in terms of section 117B5 was made clear in HA Iraq at paragraphs, I think, 41 to 44. Those should be on 321. Going over. And there's no dispute between the parties on any of this. I can deal with it, I hope, quite quickly because it is now very clearly settled. It's the MK self-direction that sets out the relevant test under section 117C5, which is identified at paragraph 41 of HA.
Yes, I mean, there's been some comment about later, hasn't the re-evaluation of what Lord Carnworth said in paragraph 23 in KO?
Yes.
Yes, so HA, there were two key issues in the Supreme Court's decision in HA and others, which I've just referred my lords, my lady to. The first was whether there needed to be some comparison to a notional, ordinary or normal position of a child in the light of what was said in KO at, I think, paragraph 23.
And the answer is no.
The answer is no, but that's not relevant for our purposes. So, my lord, if that's what my lord has in mind, then
it is.
That's absolutely right. So that's section 117C5, and I hope you have my submission here. Section 117C5 clearly calls for an objective normative assessment to be undertaken by the court or tribunal. Section 117C6 has been considered in many cases, but for our purposes, I think at this stage I need to refer you only to two of them. The first is HA, which we're already in, and in particular paragraph 51. That's at the bottom of page 323. At 51, the Supreme Court identified a bullet point list of factors that would be relevant to all the circumstances assessment that needs to be undertaken.
Well, aren't they just summarising what was said in the European decisions?
In Unani, that's right, in particular Unani, which is the most recent decision, certainly at the time of HA, at the Strasbourg level. of salience for our purposes, I would respectfully submit, are the third from bottom and second from bottom bullet points. The seriousness of the difficulties which the spouse is likely to encounter in the country to which the applicant is to be expelled, and similarly best interests of children, bearing in mind in particular seriousness of difficulties they may face in the country of deportation.
Yes, I mean that comes back. You're making the point about subjective.
Yes. So it's for the court or tribunal to itself decide whether, in fact, as a matter of reality, objectively, there are those serious difficulties. It's also fair to note that the authorities recognise that factors identified in respect of an Article 8 assessment concerning non-settled migrants are also potentially relevant. That was made clear in the Hashim Ali case, which is cited at paragraph 51 in HA, and in particular at paragraph 33 of Hashim Ali, which I hope is at page 112 of the updated authority. 112 going over.
Sorry, going back to paragraph 51 of HA,
Yes.
Lord Hamblin says that when considering whether there are very compelling circumstances, all the relevant circumstances of the case will be considered and weighed against the very strong public interest in deportation. Do you make any submission about that?
Yes, so the submission is that the reference to all the circumstances are reference to the objective facts.
Yes, I was thinking more about weighed against the very strong public interest.
Yes. Well, grounds 2 and 4 make the contention that it wasn't open to the upper tribunal in this case to conclude that.
Okay, we're going to come to it then.
I'm dealing with the
Okay.
rather more focused point, if I may respectfully say so, about the relevance or otherwise, and the significance or otherwise of subjective fear.
Yes, thank you.
But I will come on to the public interest and how that works.
So, sorry, I got 30, what did you say?
So I just wanted to make clear that factors that are also relevant when assessing 117C6 are those that have been identified by Strasbourg in respect of removal of non-settled migrants in the family life context. And that's quite clear from paragraph 33 of Hashim Ali, which is another decision of the Supreme Court, which is on page 112, going over leaf. So that sweeps in 2 additional relevant factors, potentially in this case. We've got jeunesse. I don't propose to take you to it. It's very well understood. But if you want to look at jeunesse and the relevant part of jeunesse, it's paragraph 107 of jeunesse. Jeunesse is referred to in paragraph 33.
You say if you want to look at it. We don't know.
You don't want to look at it.
If it's sufficiently important that you want to take us to the text of the Strasbourg case as opposed to sticking with our Supreme Court, then do.
I don't.
Not.
It's only necessary to look at it if there's any issue taken by Moylan in terms of what I'm about to say, and I don't expect there will be. So, jeunesse makes it clear that in this case there are 2 further factors that Strasbourg would look at. Whether there are insurmountable obstacles to the continuation of family life in the country of AB's proposed deportation, India, and also rupture of family life in the event of deportation. So drawing all of that together, what we have in this case in terms of section 117C as potentially relevant factors that subjective fear could go to are the following. The seriousness of the difficulties that AB's partner and AB's child could face in India. The insurmountable obstacles, possibility of insurmountable obstacles that they would face in India to the continuation of family life there. And finally, the rupture, the possible rupture of family life. On rupture of family life, the domestic authorities are clear, in my submission, that the court is not looking necessarily at a factual assessment. Instead, it's looking at the difficulty of the dilemma faced by the couple. That's quite clear in my submission from Lord Justice Sedley's observations in VW Uganda, which begins at page 7 of the authorities. And the relevant passage is paragraph 42. Page 7 for the start. Paragraph 42 is on page 13. So this is a case that's now of some vintage, decided in, I think, 2009, certainly reported in 2009, before significant changes were made to the immigration rules that affected the correct approach to Article 8. But what Lord Justice Sedley is explaining in paragraph 42 is the approach at the domestic court level to this idea of rupture, potential rupture of family life. And what Lord Justice Sedley explains in the last sentence is the approach that domestic courts take. It's the hardship of the dilemma, that's the dilemma as to whether to stay and leave the partner or go and live with the partner, that has to be recognised and evaluated.
But he starts off by saying some appellants will command belief, and they say that what they will do.
Yes.
So he's saying if you accept the evidence as to what they will do, then that's it. You're on firm, what does he say? Reasonably firm footing.
Well, those comments have to be read in context with respect, my lord, and the context is the first sentence of paragraph 42.
Well, exactly. He has to form a view. They have to form a view of what will follow.
Yes.
But he's saying you're on reasonably firm footing if you believe what the appellant says.
Yes. Yes.
And your submission is to the direct contrary.
Well, my submission is that what Lord Justice Sedley is explaining here is that it's the hardship of the situation that a couple are put into, where one of them is required to leave the United Kingdom, that has to be evaluated. It's not necessarily the finding of fact as to whether one will stay and one will go. That's what. So I acknowledge, my lord, that what Lord Justice Sedley says is that in some cases the fact finder might be able to make a reliable assessment of that stay or go question, if you like. But in other cases, Lord Justice Sedley says that's unrealistic and would be difficult. And that leads Lord Justice Sedley to conclude that it's the hardship of the dilemma itself which has to be recognised and evaluated. That's the last sentence.
Speaking for myself, I'm not sure I really understand what that is.
Yes.
What is the hardship of the dilemma is, what decision do I make?
Yes. So what Lord Justice Sedley is explaining in my submission is that the court, confronted with a claim that family life might be ruptured, has to make an evaluative assessment as to whether exposing the couple to that possibility is justifiable. He used the terminology of reasonable in VW Uganda. In my submission, ultimately, this boils down to the question of whether it would be proportionate to expect the family to endure that dilemma. But the important point here is that the domestic courts have not insisted on any clear-cut factual assessment of the question of rupture. They recognise that it's necessary to conduct an evaluative assessment, bearing in mind the difficulty of the dilemma that the removal of one element of a couple puts the couple in, and to ask whether that is, if you like, normatively appropriate. Is that justified, applying a proportionality assessment?
That's only one step on. I mean,
It is.
surely the tribunal has to decide or make an assessment of what they consider is objectively reasonable. I mean, that's your primary submission. I'm not going to go because, no, yes, that's very reasonable. So it will lead to, as you're describing it, a rupture in the family. Or, no, that's not reasonable. If you decide not to go, then that's your own choice.
Yes. So
And
I'm
they're two very different situations.
Yes, I'm simply pointing out that when it comes to the domestic court's approach to this idea of rupture of the family life, it's not a purely factual inquiry. There is a normative element to it, in the way that Lord Justice Sedley explains at paragraph 42. Now, I don't necessarily place great weight on this feature of the domestic case law. I don't think it ultimately, whether you accept this or not, ultimately makes a huge amount of difference here. But I am pointing out that even when it comes to something that, on the face of it, could be seen in purely factual terms, the rupture of family life, even there's need for a normative objective evaluation.
Has this been referred to in any subsequent case?
Yes, my lord, in the Runa decision, which is on page 16 and following. And at paragraph 34, counsel for the Secretary of State in that case referred this court to what Lord Justice Sedley said in VW Uganda at paragraph 42. And this court appeared to endorse those observations. Now, just to be clear about what Runa was about very, very briefly, Runa was about the correct approach to the assessment of whether it would be reasonable for a child to be expected to relocate outside of the UK for the purposes of section 117B, I think it's 6, of the 2002 Act. So it's a case that didn't involve deportation, but it's not a million miles away from what we're dealing with here.
Again, that paragraph seems to suggest that the court can ask what in fact is going to happen.
Yes. And I don't shy away from that. The court can and will, where it can make a reliable finding, determine what in fact will happen. But the reason I've taken my lady and my lords to VW Uganda and paragraph 42 of that decision is to make the point that there is still at that stage a normative evaluation that needs to be undertaken, even on that question of rupture. It's not, in other words, it's not a purely factual assessment, even on the issue of rupture.
Runa's not a deportation case at all.
No, I hope I've made that clear. It's a section 117B case, so not deportation. And the ratio of the decision is that it's necessary to conduct a fact-finding assessment in respect of 117B 6. So I don't shy away from that, but I hope I've been clear. My submission is that even on the question of rupture, you're not looking at a purely factual assessment. You're also looking at an element of normative evaluation as well.
In this case, the Upper Tribunal made a finding that the wife would be unable to go.
Yes.
And I think you say that doesn't mean unable in the dictionary sense, physically or legally unable, but unwilling.
Well, it's not clear what the upper tribunal had in mind. That's one of the points we take. But that's one possible interpretation, yes.
At any rate, it's not the sort of case where Indian authorities would refuse entry or there was some other absolute bar to going.
Yes.
But I think, Mr. Pipe, speaking of myself anyway, it is entitled to say that what that finding means is she would not go. But if you say, I think you say, well, even that's not enough, otherwise the whole scheme of 117C is blown to pieces.
Exactly.
Yeah.
That's absolutely right. It's still necessary to undertake that normative objective assessment. So if I draw try and sort of crystallise the points I'm building to here. In respect of section 117C5, it's clearly necessary for the court to make its own normative, evaluative, objective assessment in the light of its own findings of fact as to risk. In that context, my submission, a subjective fear based on an erroneous and mistaken subjective assessment of risk should not be relevant. In terms of section 117C6, the relevant factors in this case are those I laid out earlier: seriousness of difficulties to the spouse and child in the event they go to India, insurmountable obstacles, and rupture of family life. The first two of those factors in my submission plainly calls for an objective evaluation.
Sorry, can you say the factors again you were
Yes,
referring to?
seriousness of the difficulties which AB's partner and AB's child would face in the event that they went to live with AB in India. Whether there are insurmountable obstacles to the continuation of family life in India, and rupture of family life. The first two of the rupture of family life is the third factor.
Rupture of family life if she and the child don't go. Strictly in the event of AB's deportation. The first two of those three factors in my submission plainly call for an objective assessment of the facts and an objective evaluative judgment by the tribunal. So that if the tribunal concludes that in fact there is no risk, then it should not give weight, in my submission, because it would be irrelevant, to the subjective belief that there is in fact risk of the partner in this case, or it could in principle be the appellant. Because otherwise you are undermining the task of the court and its objective nature. And I'll come on to Lal in a moment to make this point good. Rupture of family life, I accept, it might be said against me, does call for a purely factual evaluation. But as I've tried to explain by reference to VW Uganda, it's not a purely factual evaluation, there's a normative element too. And that, in my submission, is consistent with the overall approach that plainly has to be undertaken in a case like this, which is an objective assessment undertaken by the court or tribunal in the light of its own findings of fact as to the relevant circumstances and characteristics of the individual. So in that context, a purely subjective belief that there's risk as the ground for, or the explanation for, a subjective fear should be discounted, even on the question of rupture of family life.
Well, surely that's a question the tribunal has, your submission is, that's the question the tribunal has to address,
Exactly.
whether it should or shouldn't.
Yes.
You can't say it should be.
Yes.
Depends.
Yes. So even on rupture of family life, even if you conclude as a matter of fact, for whatever reasons, there will be a factual rupture, you then have to go on to say, well, actually in the circumstances, is that situation one that should be given significant weight or not in my objective evaluative assessment of proportionality, bearing in mind, for example, that the person may have just stubbornly refused to leave, or, as in this case, has an unreasonable belief about risk. Now, I think it's time to take my lady, my lords to the Lal case, which is at page 169. You have the head note on 169 that explains the issues and the facts in Lal. I won't take you through that. The key issue for our purposes that was considered in Lal is whether insurmountable obstacles, the question as to whether there were insurmountable obstacles to the continuation of family life, whether it was relevant in that case that the, I think it was partner, had been found to have a particular sensitivity to heat. And the key passage is paragraph 37 on page 179. Paragraph 37, 179. So the court acknowledged at paragraph 37 that it was necessary to consider the characteristics and to make findings about the characteristics and circumstances of the individual. And it held that the finding that this partner was particularly sensitive to heat was a characteristic of the individual, and so on that basis felt to be taken into account. But the court rejected the suggestion. This is the text between line markings G and H, just after H. The court rejected the suggestion that just because the partner would not go, given the sensitivity to heat, that constituted in and of itself insurmountable obstacles, because of the need for an objective assessment as to what insurmountable obstacles means. The court pointed out that otherwise the objective assessment that is required would collapse into a subjective assessment. Now, my learned friend says against me on ground one, well, a subjective fear is a characteristic or circumstance for these purposes. My submission is that that is quite wrong. The subjective fear in this case was the result of the unjustified belief about risk. The subjective fear is simply a placeholder in this case for an unjustified or objectively incorrect belief about risk. It's not a characteristic or circumstance, and therefore it shouldn't be taken into account. One can perhaps envisage a contrast with a case where the evidence demonstrates that someone has, let's say, a profound phobia of something, which then causes a particular outcome. That might be said, that psychological position, the phobia, might then be said to be a characteristic of the person. But that's not this case. This
in,
case,
in the Lal case, after the paragraph 37, which contains the point of law on which you're relying,
yes,
and goes on to 38, where the court is not saying we allow the appeal and therefore the appellant wins outright. We're saying there is further factual inquiry, making a rather obvious point that not all parts of India are equally hot. Now, in the present case, if you are successful on any of your grounds, do you accept that the case should be remitted to the Upper Tribunal, possibly a fresh Upper Tribunal, to make the findings of fact which you say were not made, or are you seeking, as it were, an outright win?
our primary position is that we want an outright win. If the court is in doubt about the outcome, in the light of the errors that on this hypothesis will have been established, then we accept it would be appropriate to send the matter back. In other words, if further fact-finding is necessary in the light of my lady, my lord's judgment, accepting that there are one or more errors of law and that that could make a difference, the matter goes back. But my lady, my lords will appreciate that grounds 2 and 4 make the argument that the conclusions of the Upper Tribunal in respect to 117C 6 and 117C5 are perverse. They weren't open to the judge. If that's right, it's difficult to see in my respectful submission that the matter could sensibly be sent back. And the points I'm making now in respect of ground 1 indicate, if I'm right about them, that the finding about subjective fear in this case simply falls out of the picture. That's my primary submission.
Yes. All right. Well, I'm sorry I've taken you out of your course because you haven't got to grounds 2 and 4 yet.
No, and I did indicate that I would deal briefly with the relief we invite the court to give us at the end of my submission.
Yes.
Because I had in mind my lord's question.
So not to continue too far down that path we've taken you on, but is your point that even if the rupture to the family was accepted, that on basis of grounds 2 and 4, it's still not the outcome was still not permissible?
Yes,
there's only one outcome.
That is my submission.
Thank you.
And even on ground 1, there would still have been an error, and let me explain why. Because as I've explained, I hope, the relevant factors in terms of the 117C5 and 117C6 considerations, except perhaps for rupture, are all normative objective assessments for the tribunal to undertake. And yet it's clear that it did rely on this idea, this finding of subjective fear in respect of difficulties that the partner and child would face in India. So that was a clear error there. Even if it could in principle be relevant, it can only be relevant to rupture of family life. And there, as I've tried to explain by reference to VW Uganda, it's still necessary to bear in mind that the normative dimension of that element of the assessment, and it can't certainly be treated as a dispositive factor. And the judges did not consider that normative element. So that was an error of principle there. So just to finish up then on ground 1, if my lady, my lords are not with me on my primary submission, irrelevance, in my submission, it must be right, with great respect, that the subjective fear based on a mistaken belief about risk should generally be given little weight in the overall proportionality assessment. Otherwise, that assessment will be distorted. The objective normativity of that assessment will be distorted. And that's indicative of the wrong approach. And as I've just a moment ago explained, if we look back at the Upper Tribunal's reasoning in this case, the Upper Tribunal is not clear that it's looking only, well, it's clear in my submission that it's looking at subjective fear in terms of the serious difficulties that the parent, the partner and child would face in India, as well as in respect of rupture. It doesn't differentiate the approach in that regard, and it doesn't explain why it is appropriate to give any real weight to that subjective fear in the proportionality balance, bearing in mind that it is an unjustifiable fear, or maybe, if it be right, that the Upper Tribunal just didn't make any findings one way or the other as to whether there was risk as claimed by the partner. And that must be an error in my submission. There's also the point that we make in the skeleton argument that I mentioned earlier, that the tribunal failed to evaluate all the relevant circumstances in respect of the rupture issue, bearing in mind that a subjective fear based on a mistaken, potentially mistaken view of risk is likely to be unstable and so may change over time. So this would be relevant to the rupture question because it would be relevant to the duration of rupture, whether it's a permanent rupture or a temporary rupture. Especially bearing in mind the findings that the tribunal made in this case about the committed nature of the relationship between AB's partner and AB. So with respect, however you slice it, we submit that the Upper Tribunal materially erred in its approach to what we've called subjective fear, but the subjective fear is really a placeholder for the mistaken belief or potentially mistaken belief about risk. Turning then to ground 3, the challenge to the unable to go to India finding. The tribunal rests its finding to that effect on two matters: subjective fear, which I've dealt with, but also the fact that AB and AB's child were born in the UK, had lived their whole lives in the UK, and don't have connections to India. In my submission, the Upper Tribunal's reasoning is inadequate and unsustainable because it only relied on those factors, but there was a lot more for it to do. It's not clear whether the Upper Tribunal is saying that the partner is physically unable to go. I think I see the force in my Lord Justice Bean's point that what the Upper Tribunal may well be saying is that AB's partner is unwilling to go, but the implications in terms of the objective normative assessment under 117C 6 and indeed 5 of that unwillingness needed to be carefully considered and spelt out. Because it can't be right that a stubborn unwillingness to relocate on its own should be given significant weight in the proportionality assessment here. And the Upper Tribunal just does not grapple with any of that. So we say it erred. And of course, if I'm right in my arguments about subjective fear, his conclusion about AB's partner being unable to relocate to India would be undermined by the arguments I've made about the approach to subjective fear. So those are my submissions on ground 3. Can I turn to deal with grounds 2 and 4? I'll deal with them both together. Just a couple of authorities to refer my lady, my lords, to in respect of these grounds. In reverse chronological order, the first is the Capicania case at page 18 of the supplementary authorities. this court considered the Yeltsin case against a particular factual matrix, as well as ECHR. The passages that I would refer my lady and my lords to are paragraphs 41 to 43 on page 41 going over. And in particular, it's paragraphs 42 to 43 that I emphasise in my Lord Justice Bean's judgment. So it is recognised here that it's necessary to appreciate the statutory wording over and above. So you can't, at least not normally, go straight to a proportionality assessment under section 117C6. And because of the over and above expression, particularly in a case of a serious offender, the circumstances of a case where exceptions 1 and 2 can simply be bypassed must be wholly exceptional. And then at paragraph 43, it's noted and perhaps emphasised that there is a high threshold for the something more in a case of a serious offender. The other authority I would take my lady, my lords to is Yeltsin. Which is at page 190. And the key passages are paragraphs 57 to 58 on page 209.
Yes, this is the source of unduly harsh.
Yes, indeed. Indeed. A memorable phrase. Essentially, what this statutory scheme requires in my submission is that you need a very strong case over and above the exceptions in order to succeed under section 117C6, and that is because of the very strong public interest supporting the deportation of a foreign offender, given that Parliament has required that person's deportation under section 32 and 33 of the 2007 Act, and given the terms of Part 5A of the 2002 Act, in particular section 117C of that Act. Now, turning back to the instant case, and dealing with ground 2 first, in my submission, the reasoning that we've looked at in the Upper Tribunal's decision, particularly at paragraphs 38 and 39, comes nowhere near identifying the something more required in a case like this, bearing in mind AB's sentence of just over 5 years imprisonment and his offending more broadly. The factors that the Upper Tribunal identifies at paragraph 38 are at least very largely covered by exception 1 or exception 2. So whether Upper Tribunal refers to the difficulties the appellant has had as a result of growing up without a father, the length of time he's been in the UK. Those are factors in my submission that would naturally fall within exception 1. And the other factors that are identified in respect of the impact of deportation on AB's partner and AB's child, the subjective fear that we've discussed at length, the fact that AB's partner and AB child are British and live in the UK, the fact that AB is a considerate partner, the assertion that the partner, that it's possible that the partner will struggle to care for AB's child because of enduring mental health problems without explaining what they mean, what the tribunal means in that regard. But bearing in mind there's just a mere possibility there. All of those things fall within section 117C5. But in my submission, they cannot be characterised as establishing more than a base case under section 117C5. And the court will remember that the tribunal found that exception 1 was not met. So we have here a case in my submission where there's something more is missing and has not been adequately identified by the Upper Tribunal. In those circumstances, the Tribunal's conclusion that the high threshold under section 117C6 had been met was not open to it.
I think the authorities make clear that you don't have to identify specific factors that come within something more. You have to undertake an assessment and decide whether or not there are very compelling circumstances, and there's might be a very significant overlap.
Yes.
So I'm not sure that speaking for myself, that I entirely follow the submission, but that just because the factors could come within the exception means that they don't justify a conclusion of very exceptional circumstances.
I'm grateful, my lord. So the submission is that the tribunal had to explain how there was the something more required in respect of section 117C6. We know from the authorities I've taken the court to, in particular Yeltsin at 57, we just looked at, that you can make good the something more case by showing a very strong case under one of the exceptions, or by pointing to factors that fall within the exceptions and then factors that fall outside of them, but then showing overall that you've got a very strong case. My submission is that the factors that the Upper Tribunal identified in this case do not, on any reasonable and sustainable view, show that either was the case. There was not a very strong case in respect of the exceptions. Exception 1 failed, and section 117C5, the case there could at best be described as a base case. And looking at the situation more broadly, the tribunal failed to identify factors that indicates that this is a very strong, sufficiently strong Article 8 claim. So in my submission, the Upper Tribunal erred because in the light of the reasons it gave, it was not open to it to conclude that the something more had been established. Or in other words, that the section 117C6 threshold, bearing in mind how high that threshold is in the light of the public interest underlying the decision making in this case, had been reached. So that's our case in respect of ground 2. And I should say, one indicator in support of that point is the tribunal's reliance on subjective fear, which I say at most should be given little weight in this case and wasn't properly explored. At most, being generous to the Upper Tribunal. So that's our case in respect of ground 2, the challenge to the 117C6 conclusion. We do also submit that the judges erred in respect of 117C5. And the submission is that the factors that the Upper Tribunal relied upon did not show, on any reasonable view, that Section 117C5 had been met, applying the MK self-direction that we looked at paragraph 41 in HA. The Tribunal relied on the following factors. The fact that the partner and AB's child were British citizens with no connection to India, the fact that they'd lived all their lives in the UK, the subjective fear, the fact that AB is a considerate partner, and the fact that, without explaining what it meant, it said that the partner has significant enduring mental health problems, and the possible impact on AB's partner's ability to parent. In my submission, those factors do not show, on any reasonable view, that the elevated threshold that MK self-direction makes clear is applicable had been met. Subjective fear fell at most to be given very little weight and was not adequately explored. The fact that the partner and children are British with no connection to India is not a cogent factor in my submission, or at least it's not a very weighty factor. Similarly, the fact that they've lived all their lives in the UK, bearing in mind the age of the child, that's perhaps unsurprising. And the point about enduring mental health problems, as I've pointed out at various stages in my submissions, is unexplained, and there seems to be very little evidence in support of it. I took you to the evidence in the independent social workers report. That seems to boil down to the assertion that AB's partner made when discussing her circumstances with the independent social worker. And if we just go back to...
You need not repeat what you said
you've made a note.
about half an hour ago.
I'm grateful. You've got it. That, in my submission, is not a particularly weighty consideration. And the possible impact on a partner's ability to parent, because of the way it's couched in terms of possibility, naturally falls to be given little weight. And so if we're right about that, the judge's conclusion in respect of 117C5 was wrong, and that must be fatal to its overall conclusion in respect of section 117C6. Finally then, my lady, my lords, unless there are any further questions on relief, I think I've already covered this in answer to my Lord Justice Bean. But we submit that if you accept our arguments in respect of grounds 2 and 4, those are the perversity arguments, then AB's appeal from the Secretary of State's decision should be dismissed, and so it's not appropriate to remit. We win outright, if you like. It would only be appropriate to remit if the court was of the view that the tribunal could reach a different conclusion in the light of the reasons it gave, if perhaps it had applied the correct principles, particularly on the question of subjective fear. In my submission, there's actually very little reason to think that that is the position. But if the court is of the view that that is the position, then I accept that the matter should be remitted for a fresh hearing. My lady, my lords, unless you have any questions, that's my submission.
Thank you very much. Yes,
My lady, my lords, in seeking to persuade you that there is not an error of law in the decision, perhaps my learned friend has taken you through the decision. Can I just highlight some points before touching upon the law and then looking at the detailed findings on the central issues? So looking in the core bundle of the decision of the Upper Tribunal, as my learned friend has indicated, the preserved findings are set out at paragraph 7. The the issues at paragraph 8, the sentencing remarks at paragraph 9. In terms of the evidence, my learned friend referred you in particular to the evidence of AB's partner at paragraph 12 and 13 and paragraph 14 in relation to AB's sister-in-law. I do need to touch upon paragraph 11 and addresses a question from the court. It does seem that there was a medical report before the Upper Tribunal. The only reference to it is within the Upper Tribunal's summary of AB's evidence at paragraph 11 on page 29 of the bundle. In the middle of that paragraph it says her family live about 2 miles away, and this is talking about the rupture with the family on the AB's partner getting into a relationship with him. The appellant was referred to paragraph 7.12.1 of the report of Professor Saeed Afghan dated 25th Jan 2023, which records that according to RJ, she experienced a significant backlash from her own family. However, the problems appear to become less significant over time. That is the only reference to that medical report. I took brief instructions during my friend's submissions from my instruction solicitor who sits behind me. I understand there were medical records and a psychiatric report before the Upper Tribunal, but I accept the only reference to it is within paragraph 11 in passing in relation to AB's wife's relationship with her family. The tribunal set out the legal framework of paragraphs 15 through 20 of their determination, and it's important because there is a correct and careful direction on the law. I need not remind the court of what was said. I think it was most recently said by Lord Hamblin in the HA case at paragraph 72 about approaching decisions with caution and restraint when there is an appropriate direction, and the statutes referred to along with HA Iraq in paragraph 51, and also the most recent decision at that time in Yalsin at paragraph 20 with the citation, and I think it's cross-referring within Yalsin to Lord Justice Underhill's judgment in the Court of People, in HA Iraq, where Lord Justice Underhill cited the something substantially more paragraph at 57. That's on page 33. In terms of, I accept there's no reference to LAL within the self-direction. I submit that would be expected. This is obviously a deportation case. They've directed themselves as to the statutory provisions they need to consider, and also to the most recent case law in relation to that, LAL obviously being authority in relation to EX1B and insurmountable obstacles.
Well, hang on. Are you saying it's irrelevant?
No. What I'm drawing at that point, my lord, is that the self-direction is comprehensive and correct, notwithstanding the lack of reference to LAL. One wouldn't normally expect within a standard direction, within a deportation case. I'm conscious to mirror what was said by Lord Justice Underhill in Yalsin, not making decisions of the tribunal more complicated than they need be, to expect them to set out at this stage a paragraph from LAL in relation to how insurmountable obstacles is being interpreted. Clearly it may need, or the correct approach needs to be mirrored, and I say they didn't collapse the test into a subjective test, and they applied the correct test when they came to deal with the matter of subjective fear. But the point I simply make at this stage is that there is a comprehensive self-direction covering the necessary statutory tests and the recent case law as to the correct approach both to the test set out in 117C6 of very compelling circumstances and the appropriate approach to the unduly harsh in 117C5, exception 2. Within Article 8, just before I turn to that, at the bottom of paragraph, page 33 of paragraph 62, they cite, they're citing from Yalcin, the proportionality assessment is generally multifactorial and requires a holistic approach. And then it says a tribunal must, of course, in its reasons, identify the factors to which it has given significant weight in reaching its overall conclusion. It is no doubt also desirable that it should indicate the relative importance of those factors, but there are limits to the extent to which it's practically possible. The tribunal deal with Article 8 on page 35 and following, starting at paragraph 26. They accept, as my learned friend has indicated, that there is a genuine subsisting relationship with a qualifying partner and the daughter at paragraph 27. And they're keen to direct themselves at paragraph 28 that there are very compelling circumstances required in a case such as this because of the length of the sentence imposed. And at paragraph 29, they reiterate what is said by counsel, or the acceptance by counsel for AB at that time, that the appellant has a high hurdle to cross. They then identify exception 1 and address exception 1 in paragraphs 30 through to 31 and find the appellant does not meet exception 1. Can I just pause at this point, just because it was something Lord Justice Moylan raised with my learned friend in relation to the exception 1 factors. Whilst the AB did not meet exception 1, those factors did not then cease to be relevant when the Upper Tribunal came to weigh a full proportionality assessment within considering 117C6. So the inability to meet an exception does not rule out characteristics in assessing whether there is something more required.
Just a small point on the narrative, paragraph 29. Tribunal found him not been lawfully resident in the UK for most of his life. They don't explain why. It wouldn't, even if they were wrong about it, it wouldn't get you home because they go on to significant obstacles. But was he unlawfully in the country at some point between age 11 and age 28?
That's what I understood. He entered in 2007, and it was only in 2016. Paragraph 2 on page 26 claims to have arrived in the UK on or about 2007.
Oh, right. He doesn't get leave to remain until 2019.
So in terms, as my lord will be aware, and I don't want to dwell on this because obviously exception 1 is not in play, 3 limits to exception 1. Obviously he wouldn't meet the first 2 because he hasn't been lawful present for most of his life. They look at the sort of key element of exception 1 and whether there be very significant obstacles to integration, find that it's not met. But this point I make is those points can be then brought forward in the consideration of whether there is something more. In terms of the exception 2, they move on to consider this at paragraph 32. They say the appellant is in a genuine subsisting relationship with a qualifying partner, and he has a genuine subsisting parental relationship with a qualifying child. And they say this, we were particularly impressed with the evidence before us from RJ, who we found to be an honest and credible witness. So certainly there was an acceptance of the evidence as honest and credible. They then talk about there being no connection to India as British citizen, and say we accept the evidence of RJ that she would be unable to join the appellant in India because she was born in the UK and has lived here all her life. We also accept her evidence that she has a maternal uncle who is a politician in Pakistan, and that he has connections to India. She believes that it is likely to put her and her daughter at risk. She fears she will be targeted in India. And then they note, Mr. Bates represented the Secretary of State before the Upper Tribunal, and that this came out in cross-examination, but found her evidence was entirely consistent in the way the evidence had come out. And it says this at the penultimate sentence of paragraph 32. Whether or not RJ's maternal uncle has any reach in India, it is clear that RJ has a subjective fear that she and her daughter will be targeted in India. That is a risk she is not prepared to take. So in answer to the questions posed by the court to my learned friend, I don't think this is a case where they're finding she's physically unable to go, but it is clearly unwilling to go because of the way it is accepted. I think that is also brought out, just as an aside, by Judge Mandelia's refusal of permission to this court. It's it's page 18 of the core bundle on his paragraph 6. And he says this: the tribunal found at paragraph 32, so that's the paragraph we were just looking at, the appellant's partner to be an honest and credible witness. The tribunal accepted her evidence that she would be unable to join the appellant in India because she was born in the UK and has lived her all her life. Importantly, it also accepted her evidence that she has a maternal uncle who is a politician in Pakistan and that he has connections to India. The tribunal found she has a subjective fear that she and her daughter will be targeted in India, and that is a risk she's not prepared to take. So that perhaps sheds light on his earlier finding at paragraph 32 in relation to the subjective fear. They don't say that's an unfounded or irrational fear, but it's based on her perception and her being accepted as a honest and credible witness. To put in contrast with the paragraph from VW, from Lord Justice Sedley, this was not somebody who was trying to blackmail the tribunal by saying I can't go and hold the tribunal to hostage in any way, but being an honest and credible witness where her evidence dovetailed. Importantly then, at paragraph 33, the tribunal says the question arises under exception 2 whether the effect of the appellant's deportation on the partner and child would be unduly harsh. The term unduly harsh involves an appropriately elevated standard, and we must make an informed assessment of the effect of deportation on RJ and HA and make an evaluative judgment as to whether the elevated standard has been met on the facts and circumstances of this appeal. I would submit at that paragraph, at paragraph 33, that the tribunal accurately encapsulate the task that they have to conduct. Perhaps this was most authoritatively and most recently set out by the Supreme Court and Lord Hamlin's judgment in the HA case. And at paragraph 44 thereof, the reference is at 322 of the amended authorities bundle.
Sorry, which paragraph?
44, so it's
Thank you.
A in the margin top left. My learned friend has used phrases such as objective, normative, etc., but the way in the modern formulation of the test that has to be considered in whether there is the effect of deportation, because the question we're answering in the modern, post the amendments and the new Part 5A and Exception 2, is whether the effect of deportation would be unduly harsh. And Lord Hamlin said at paragraph 44, it is for the tribunal to make an informed assessment of the effect of deportation on the qualifying child or partner and make an evaluative judgment as to whether the elevated standard has been met on the facts and circumstances before it. So can I draw 3 phrases out of paragraph 44, because I think it's a helpful way of looking at the exception 2 test. There's an informed assessment, then an evaluative judgment of whether the elevated standard has been met. So that is the task of a tribunal, assessing whether the effect of deportation is unduly harsh.
Well, as to which you go back to paragraph 41.
Yes, my lord. You anticipate where I was about to go.
Yes.
And the MK, and I know they say it's full of adjectives, but it's been approved both in KO and in HA. What was said in terms of unduly harsh being bleak and the antithesis of pleasant and comfortable. And just turning back to the determination, page 37, paragraph 36 of Judge Mandelia's judgment, when they consider the facts and circumstances, they echo that MK direction. So if one looks at the end of paragraph 36, it says this: we reach that decision having noted that unduly harsh does not equate with uncomfortable, inconvenient, undesirable, or merely difficult. Harsh in this context denotes something severe or bleak. So whilst not saying at that point CMK,
Yeah.
It's clearly mirroring the verbatim language thereof. Just to tie up the logical flow, so 32 deals with the subjective issue, if I could call it that. 33, the evaluative exercise, and I would say the correct approach in terms of tribunals, because I think there's a danger of getting confused about normative, objective. It's this evaluative exercise, looking at the informed assessment of the impact of deportation, and then whether that elevated standard has been met. There's reference to the independent social work report there, and the report it doesn't seem to have been challenged in the refusal of permission by Judge Mandelia, who refers to the unchallenged independent social work report. The report speaks to the appellant's relationship with his daughter and the family dynamics regarding the breakdown of the relationship between RJ and her own family. So it's more than just a best interest assessment. In this case, it also looks at the particular fragilities of AB's wife, and my learned friend has helpfully referred you to the 2 paragraphs where that's dealt with within the social work report. At paragraph 35, the Upper Tribunal deal with best interests. And then at 36, they draw those threads and say, as we have said, we found the evidence of RJ to be compelling, and we accept her evidence of the particular family dynamics, including the breakdown of RJ's relationship with her family caused by her entirely understandable unwillingness to marry a relative, as proposed by her parents, and instead to pursue and maintain relationship with the appellant. So the first factor they set out is the particular family circumstances that have arisen vis-a-vis the appellant's partner entering into the relationship with him. We've taken into account the evidence before us regarding the health of RJ, so health also played a factor, and her subjective fear that she will be at risk in India. So they do there refer to the subjective risk in India, so that the family could not continue to live together in India. Looking at the evidence before us holistically, and having considered all the evidence before us, we find that in the particular circumstances that the appellant RJ and HA find themselves in, the particular family dynamics are such that the effect of the appellant's deportation on his partner and child would be unduly harsh. In my submission, what the Upper Tribunal are doing there, it is exactly what the Supreme Court had indicated they should, as per paragraph 44, in conducting an informed assessment of the effect. They've made an evaluative judgment looking at all the facts and circumstances and found that the elevated standard is met, and they must have found the elevated standard is met because we go on to that final or penultimate sentence in terms of the does not equate with uncomfortable, inconvenient, or undesirable. In terms, before I move on to the 117C6, it's perhaps an appropriate time to consider the relevance of the subjective fear. In my submission, the Upper Tribunal or the Tribunal are entitled to consider all of an appellant's and or partner's particular characteristics when making an assessment under exception 2 and whether the effect of deportation is unduly harsh. I agree it is impermissible to collapse that assessment into a merely subjective exercise. You've been referred 32, and Lady Justice Elizabeth Lang referred to paragraph 37 of Lal. That is at page 179. I know you've already been taken to it. And in paragraph 37 thereof, this is addressing the insurmountable obstacles test under EX1, even though it is a different test.
So sorry, which page?
So that's 179 of the bundle. It's paragraph 37 of the Lal judgment.
Oh. Yes.
To start off, I don't think there's any difficulty with using the way the courts have interpreted tests such as the insurmountable obstacles and apply them mutatis then to the consideration of exception 2. I think a similar approach is appropriate, bearing in mind the wording of the particular test under the particular rule. At paragraph 37, it said that it is relevant and necessary addressing these questions to have regard to the particular characteristics and circumstances of the individuals concerned. In my submission, that doesn't close off. My learned friend said, well, that's fine in respect of Mr. Wilmhurst, who was the husband in the Lauer case, and his sensitivity to heat. But it's different in relation to a subjective fear that's honestly held. I would submit that that doesn't close off that. And it, in fact, it is the words particular characteristic and circumstances embraces the situation that the tribunal found themselves here when they've got a credible witness. But, of course, the test, in this case, EX1, couldn't be satisfied just by establishing the individual would perceive the difficulty as insurmountable and would be deterred by it. Similarly, exception 2, unduly harsh, wouldn't be satisfied just by a subjective perception, but that doesn't mean the subjective element is not relevant to the evaluative exercise. Or always has to be given very little weight, because that would be a matter for the tribunal within the bounds of rationality on the evidence before it. My lords, can I refer to, it's referenced in my skeleton argument, but the case of NC, the first paragraph I was going to refer to is at page 373 of the amended authorities bundle. It starts at page 368.
Sorry, which page?
368 it starts, in case of NC. This, unfortunately, we come across another test in the immigration rules. This was the very significant obstacles to integration. So this was the test that was in 276 ADE at that time, now is in Appendix Private Life. So this is a non-deportation case, looking at whether there, for somebody who's been here under 20 years, and whether there are very significant obstacles to integration. There's been an asylum claim from an individual from St Kitts and St Nevis. The judge in the first year had allowed the appeal under very significant obstacles to integration, but had dismissed the asylum claim, finding that while she held a subjective fear of being targeted by gangs, that wasn't objectively verifiable, but had gone on to allow it on her subjective fear under very significant obstacles to integration. That was overturned by the Upper Tribunal, and then finding that the first year impermissibly focused solely on the subjective factors, and the matter came before this court. And it's helpful at page 373, bottom of the page under submissions, para 16.
Should we read on from 16 or?
I'm going to 16 encapsulates it. Then the only other paragraph I'm going to refer you to is paragraph 25, because there, I think it's Lady Justice Whipple helpfully summarises the principles without having to go through it. but it's about council's agreement in relation to subjective factors at the top of page 274, which is helpful.
Right.
My lord, the point in relation to that, in relation to paragraph 16, the test of very significant obstacles, it was agreed also involved a broad evaluative assessment. It was accepted by both parties that subjective factors to do with an appellant's own perception of risk and fear of harm could at least form part of that assessment, but obviously objective factors were also relevant.
Yeah, it's always a bit dangerous to rely on a passage in the judgment which say council were agreed on X or there was no dispute about X unless the judge goes on to say and they were right.
Which she does at paragraph 25.
Yes, I've got 25 in front of me.
And shall I suppose I should just go back to 24.
Yes.
Because what informed that consideration was the very paragraphs of Lal addressing the third test, the EX1 test, the insurmountable obstacles test.
Yes.
So paragraph 25 is a summary. It is not in doubt based in these authorities. One, broad evaluative judgment. In that case, it's the Kamara case. Two, the judgment must focus on the obstacles to integration of their significance. That's the Parveen case. But then in relation to the subjective element in Roman 3, the test is not subjective in the sense of being limited to the appellant's own perception of the obstacles through integration, but extends to all aspects of the appellant's likely situation on return, including objective evidence, and requires consideration of any reasonable step that could be taken to avoid or mitigate the obstacle. Reliance particularly then on Lal, which was, as I said, a different test. So in my submission, the way this court has interpreted and applied the paragraphs of Lal cited in the grant of permission by Lady Justice Elizabeth Lang and by my learned friend do not exclude subjective factors, but in fact, the way they've been interpreted, albeit in the context of a different test, but a similar broad evaluative exercise in regard to obstacles upon return, has been to include those subjective factors. So in terms of my learned friend indicating that these factors were not relevant, in my submission they are relevant, and the way that Lal has been interpreted by this court in context of other rules has affirmed that in its broad evaluative judgment. Within my skeleton argument, I also cite a Upper Tribunal case of MAB, where again it cross-refers to the individual. The focus is solely upon an evaluation of the consequence and impact upon the individual concerned. That's in the context of KO, of not balancing it against the public interest, but I would submit that supports the fact that individual factors are relevant. The approach the Upper Tribunal adopted was to look at the exception and then apply those findings in its assessment of 117C6, the proportionality assessment. So I would submit if those factors, subjective factors, were relevant in the context of exception 2, they would be of course relevant when considering the proportionality assessment of whether there were very compelling circumstances over and above. In HA at paragraph 5, Lord Hamblin confirmed that it is a full proportionality balance. I accept what my lordship said in the Capicania case, that one mustn't lose sight that one is answering the question set out in the statute in 117C6 of whether there's very compelling circumstances. So it's not a freewheeling balance. It is constrained within the statutory framework, which has sort of set the scales that is required for this type of offender. But what it doesn't do is close the considerations that can be looked at. And of course, then it is a matter of weight for the tribunal. So the tribunal, going back to the judgment, say at paragraph 37 on page 37, here the fact that the appellant's deportation on RJ and HA, and that's interesting, it hadn't occurred to me, obviously you can meet exception 2 if your deportation is unduly harsh on a qualifying partner alone. You could meet exception 2 if exception 2 it's unduly harsh on a qualifying child alone. Interestingly, in this case, the finding is that it's unduly harsh on both partner and child. So there's a sort of double unduly harsh effect, both, two aspects. But they then say that's not enough. The public interest nevertheless requires the appellant's deportation unless there are very compelling circumstances over and above. So again, they come straight back to the high nature of the threshold. In paragraph 38, they then set out factors in relation to AB himself. As I've indicated, even though exception 1 was not met, I submit those are relevant factors in assessing this proportionality balance. So they look at his own personal difficulties, his father's conviction for a murder, the fact he's been in the UK since childhood, the fact he's been here for 16 years. They've already noted the fact that a lot of that time was illegal, as we've already looked at, so they're fully cognizant of that. That he's a national of India, that RJ and HA are British citizens who have no connection. Then there's the added dimension concerning the appellant's conversion from the Sikh faith to Islam. So again, whilst he couldn't satisfy the Refugee Convention, this is still a relevant factor. They factor in looking at whether there is something more. And they say, and the impact that has, so his conversion upon the ability of the family to live together in India in light of the subjective fear held by RJ. So they bring in the subjective fear, allying it to his conversion from the Sikh faith to Islam. Again, they're satisfied with the close relationship, and then they give the history of the relationship from 2017, and the fact that his wife is from a strict conservative Muslim family, and her family do not approve of the relationship with the appellant, not least because she was expected to marry a family member who had been identified and has had to make her own sacrifices to pursue and maintain a relationship with the appellant. And they say, we accept that she fled her family home feeling she would be a victim of an honour killing. She has remained resolute in her commitment to a relationship with the appellant. We accept the evidence of RJ that she will be unable to join the appellant in India. Therefore, if the appellant is deported, it is likely to lead the breakup of the appellant's relationship with RJ, and in consequence, the breakdown of the relationship between the appellant and HA. and then both RA and HA have no connections to India. Solidarity of their social and cultural ties in the United Kingdom. So this was a case where it's not just, obviously we know that there's the bare unduly harsh, as was said in Yalcin, that can be the additional unduly harsh factors or other factors. They found it doubly unduly harsh, or unduly harsh on partner and on child, but then they've looked at specific factors that relate to the appellant and in relation to the family dynamic and the history of the family breakup between AB's partner and her own family when she entered into the relationship with AB. I cite in my skeleton argument the recent judgment of Lady Justice Elizabeth Lang in the Akhtar case. It's at 426 of the bundle. Yes. It's a simple point there. It's paragraph 43.
Sorry, 426.
My lord, yes. I think this was a medium offender that wasn't accepted and having unduly harsh, and then there was a challenge to the assessment of, by the appellant in that case, who had failed under very compelling circumstances. Same judge, actually, Judge Mandalia, and it said, against this background, I do not accept that the Upper Tribunal was required to list when considering whether there were very compelling circumstances all the factors it had taken into consideration. Considering the exceptions, still less, it was required to list only the factors which were potentially favourable to Mrs. Akhtar. The Upper Tribunal had to make this decision about very compelling circumstances against the backdrop of all its findings about the exceptions. And that's important, actually, because that goes to support my point in relation to the exception one factors don't fall away when looking at proportionality. And then it is clear then that the ladyship says that they've clearly taken into account those matters. So looking at the determination as a whole, I would submit the tribunal were entitled to find, for the reasons in 36 that deportation was unduly harsh on both RA and HA, that they properly looked for the something more, and they've identified the something more within paragraph 38. Within my skeleton argument, in case it's not obvious, I set out all the paragraphs where, it's in my paragraph 43 of my skeleton argument, all the paragraphs where they set out the public interest and the nature of the offending and the seriousness of the balance. It's quite clear that they were cognizant of the nature of the appellant's offending. They set out the agreed findings, which included the nature of his offence and that he was a serious criminal under section 72. They set out in detail the sentencing remarks and are very cognizant of the public interest. Stepping back then to my learned friend's grounds, I would submit in relation to ground one that the Upper Tribunal has not erred in its approach or given unreasonable weight to the appellant's partner's subjective fear. As I've tried to show, the way LAL has been interpreted, and LAL itself, I would submit, permits the consideration of subjective factors as long as these are now conducted in that evaluative assessment, looking at the test as it's encapsulated within that paragraph 44 of Lord Hamlin's judgment in HA Iraq, rather than going back to VW and what Lord Justice Sedley said in 2009. I think that modern interpretation in the light of the statutory and immigration rules provisions provides a clear rubric for tribunals to follow. It does not rule out subjective factors, but it doesn't collapse it into a merely subjective test. I would submit they were entitled to take into account and haven't given unreasonable weight to that factor. Consequently, I think ground three is probably closely allied to that. My learned friend argues that the inability to relocate is a perverse finding. I would submit they've made clear findings as to the position of the appellant's partner, who was found to be credible, and they've assessed it in the real world context, which they must do.
Well, I think on the unable issue that I detect there's really nothing between it. And if unable means physically or legally unable, then there's no evidence of that, and therefore the finding is perverse.
I agree.
If, as I think you accept, it means unwilling, then Mr. Biggs says that's not enough, but one doesn't have to go into question of whether a finding of literal inability is perverse.
Yeah, I think it must be unwilling.
Yes.
And that's why I looked at what Judge Mandela had said when refusing permission and interpreting his own finding, that was an indication. But again, the final, forgive me, the penultimate sentence and the final sentence of paragraph 32 on page 36, whether or not RJ's maternal uncle has any reach in India, it is clear that RJ has a subjective fear that she and her daughter will be targeted in India. That is a risk she is not prepared to take. So that clearly sets out what my lord has indicated. So, and there's not, I would submit the use of unable, it's clear when the determination is read as a whole what the Upper Tribunal mean in this case by unable, that it's a risk, they repeat, it is a risk she is not prepared to take given the circumstances, and that is borne out substantively in paras 32, 36 and 38. So I would submit their finding, when properly interpreted on the face of the determination, is not perverse. Similarly, I would submit both their findings under 117C, I'll take them in the logical order, 5, unduly harsh. So that's ground 4. It is not perverse. They've conducted the assessment that they were tasked to do, mirroring the language set out in the case law, particularly AJ Iraq. They've made clear findings of why it is unduly harsh, which were entitled to them, taking into account proper factors and not giving any unreasonable weight to that subjective element. It was one of a number of factors. And then consequently, they've carried forward those findings into the very compelling assessment, adding on factors in relation to exception 1, even though exception 1 wasn't met, and factors in relation to why the appellant had claimed asylum. And his conversion wasn't at issue, so there wasn't any credibility to reach sustainable findings and show the something more with a combination of sort of extra and duly harsh plus other findings as per Yalcin, being fully cognizant of the public interest. So I submit that answers ground 2. So in my submission, the decision should stand and is not vitiated by legal error in any of the grounds, unless I can assist further.
Thank you very much, Mr. Pye. Mr. Biggs.
Thank you very much, my lord, my lady, my lord. Just 3 brief points. So firstly, despite my learned friend's focused and able submissions, he has not identified an answer to our point that subjective fear, where that fear is based on a mistaken or potentially mistaken subjective assessment of risk, so personal assessment of risk, is not a characteristic or circumstance that falls to be taken into account pursuant to the reasoning in Lal at paragraph 37. As I submitted in opening, fear in that context, where it's based on a subjective assessment of risk, is not a characteristic or relevant circumstance. I indicated in opening that it might be different if the fear was based on some psychological condition that was properly evidenced, but that's not this case. And in my submission, paragraph 25 of NC, that my learned friend relied upon, strongly supports this analysis. If we go to NC at page 377, paragraph 25 thereof, the third point that's identified in that passage is inconsistent with my learned friend's arguments on the facts of this case. The test is not subjective in the sense of being limited to the appellant's own perception of the obstacles to reintegration. Now, adapting that language to the circumstances of this case, the fear in this case was the basis of an assessment of risk that was limited to AB's partner's own perception. So the fear in this case is a placeholder for the subjective evaluation of risk.
Sorry, can you say that again?
Yes. So adapting the language in paragraph 25 of NC, page 377, to the facts of this case, the subjective fear was based on an assessment of risk that was limited to, that is based on, limited to AB.
Well, I'm not sure about that. I was thinking about this when, if Lady Justice Whipple had said, in the sense of being based on the appellant's own perception of the obstacles of reintegration, your point might be right, but she's not saying here, is she, and I don't think you were saying in opening, that the appellant's subjective perception is irrelevant. You just say that it should be given relatively little weight, and the tribunal placed a great deal of weight on it.
Yeah, I mean, that is undoubtedly the position. That's our alternative submission. I do say that actually where the fear is a subjective fear based on a subjective assessment of risk, only on a subjective assessment of risk, then that is irrelevant because it's for the tribunal to decide whether there's the relevant risk or not. And so I'm adapting the language in paragraph 25.3 to the circumstances of this case. And you are left with a situation where the fear was the result of, in this case, AB's partner's own perception.
Sorry, speaking for myself, that submission seems to be completely contrary to what is said in paragraph 25, which is that the assessment is not limited to the appellant's own perception. So in other words, you take into account the appellant's own perception.
Yeah, well, if you just look at paragraph 25, 377, judgment, the second point, judgment must focus on the obstacles to integration. 3, the test is not subjective in the sense of being limited to, etc. And in my submission, what we're dealing with it here is a subjective view about risk that by AB's partner that leads to that's effectively what the tribunal is referring to in respect of this label, subjective fear. And that is contrary in my submission to the tribunal's task of objectively assessing whether in fact there is a risk or not. That's the point I'm making.
Well, I think you say that they were entitled to find that she had a subjective fear, but you say they should have gone on to say, was that fear objectively justified, objectively reasonable? Not that one sort of forgets that it's there at all, because it's obviously a significant part of the story. That's why she's unwilling to go to India.
Yes, my lord, I think I do accept that.
Okay.
And my learned friend has, this is the next point in my revised submission, my learned friend has no answer to that with respect. Paragraph 25 of NC that we just looked at is certainly consistent with that, because the last part of paragraph 25 explains that it's necessary to consider what reasonable steps could be taken to avoid the obstacle. That was the context of paragraph 25. In this case, it was necessary in my submission for the tribunal to consider a number of factors on the question of the implications of this subjective fear and how that fell to be factored into the overall assessment of proportionality or to the application of section 117C, 5. Obviously relevant factors in that regard are, as my lord puts to me, whether the subjective fear was justified or not, because if it wasn't justified, that must be a highly significant consideration when assessing overall proportionality. Secondly, whether it was reasonable, again adapting the language of NC at paragraph 25, whether it was reasonable to expect AB's partner to overcome the subjective fear. And that's consistent with the approach taken in VW Uganda at paragraph 42 in my submission, as well as NC at paragraph 25. So there really is no answer to that analysis of the Upper Tribunal's decision. Those factors had to be identified and addressed by adequate reasoning. But instead, the Upper Tribunal gave, on the face of it, very considerable, at least considerable and significant weight to the subjective fear without undertaking that assessment. And that's, on any view, in my respectful submission, where the Upper Tribunal went wrong. And finally, but similarly, in respect to the point about AB's partner being unwilling to go, my learned friend did not identify an answer to the way we put our argument in this regard. The argument in this regard is that it wasn't sufficient for the Upper Tribunal simply to say, well, you're unwilling, AB's partner, to go, and I'm going to give that significant weight. The tribunal had to go on and explain whether it was reasonable for AB to say, I'm unwilling, in the light of relevant considerations, such as whether the subjective fear that seemed to be motivating that unwillingness was objectively justified or not. My lady, my lords, those are my submissions, unless you have any questions.
Thank you both very much. It's not absolute requirement that you should have finished by 1 o'clock, but you have. We're grateful to you. The argument on both sides was put concisely and very ably. We will reserve judgment. As you both very well know, we will hand down, we will send out a draft judgment in the usual way, not for points to be re-argued, but for correction of any factual errors, typos and so on, and for the parties to agree an order. I hope any submissions about anything on which you can't agree to be made in writing. We will then hand down the judgment in the modern sense of having it placed on the National Archive website and so forth in the usual way, and until that is done, the outcome of the case is to be confidential to the parties. That is the appellant and his family and anything that anyone who needs to know within the Government Legal Department or the Home Office. Thank you very much for your assistance.